Let's talk for just a few minutes about the reasons to create an offshore trust as opposed to, a domestic trust in your state or another state in the U.S. First, I want to, the first item there, it says foreign legal person created. What does that really mean? A foreign legal person is created. Well, we said that triune, that shaded triangle, represents a juridical person. It's the creation of a juridical person. So if we've birthed a juridical person, what's the nationality of that juridical person? It's not the nationality necessarily of the grantor, and it's not the nationality of the trustee, and it's not the nationality of the beneficiary. It's the nationality of where the trust is set up, where it's established, where it's domiciled. Just like you can go and incorporate a company in Delaware, you can go and establish a trust in Belize or Cook Islands or Liechtenstein or Malta. Okay? Where you create the trust becomes the nationality of that trust. So if you are concerned about, there's a lot of things you could be concerned about as a U.S. person, but in recent years, one of those things has been that as a U.S. person, many banks and brokerage firms around the world don't want your business. The door's closed to Americans. They say, ooh, bad, we don't want to have to interface with the U.S. IRS. We have concerns about FATCA. We don't understand how that's going to impact us. So we don't want U.S. persons. Door closed. Okay? Now, if a U.S. person goes to a foreign jurisdiction, creates a trust, that a lot of times those same bankers that won't entertain that account for a U.S. person will look and say, oh, well, this is a trust domiciled in Belize, and we don't have any issues or problems with opening accounts for a Belize juridical person, right? So that's how you can use the foreign trust to open doors that maybe have been closed to you. Not only the banking system, the SEC, Securities and Exchange Commission, is another area that claims a global mandate. Whether they really, I've heard and read other countries say that the United States Securities Commission position on enforcement violates international law because it takes it claims jurisdiction really over the whole world where U.S. persons are involved. So, for example, a client of mine recently asked me to look at a hedge fund and review a private placement document for him, and the hedge fund was based in Malaysia. So I got the URL, and I went to look at the private placement document online, and I got to the website and I started to read it, and I was maybe on page 3, maybe 5 minutes into it, when a little message came up and said, we've detected that your URL is emanating from inside the United States, and this may not be, presented to U.S. persons. And my screen went blank. I was like, wow, talk about Big Brother. You're reading it 1 second, and poof, it's gone. So why was that? Well, because the U.S. Securities and Exchange Commission hadn't deemed this to be something that, they hadn't applied for an exemption from securities laws. They hadn't applied for any kind of legal status in the U.S. And because of that, even if the client was, let's say it was a U.S. person living in Germany, they still couldn't buy the investment. But if they had a trust in Cook Islands, because that Cook Islands trust was considered a Cook Island person and not a U.S. person, they could look at the same document. In this case, I just contacted the foreign trustee and said, hey, can you get that document and download it and send it to me? Which they did, and ultimately they did make an investment through their trust. So that's one reason to create a foreign legal person. Secondly, not subject to U.S. courts. We talked about this a little bit yesterday, right? You have the full faith and credit clause of the United States Constitution as between states, but not as between countries. There are treaties that enforce jurisdictions between certain countries. Tends to be the developed, Western, industrialized, high-tax countries that have those types of enforcement procedures. Generally, not the asset protection, international tax haven type countries. They would generally not have those types of treaties with a country like the United States or any other. Next, no limitations on duration. Most U.S. states required that assets in a trust be designated to pass to an heir that's living. So it's called a life in being, which means you can leave assets to your children, you can leave assets to your grandchildren, you can even leave assets to your great-grandchildren, assuming you have them. But if you said, hey, I want to create a dynasty trust to go on for the next 1,000 years and provide support for my heirs, for education, for health, for some kind of particular reason, in most states you can't do that. Nevada now has a trust that the duration has been set at 365 years. So there are a few that are trying to mirror what's happening in the outside the United States. We still like a lot of foreign jurisdictions for that point because there is no limitation on duration in many of these jurisdictions. So it's up to you how long you want your assets to go on, and how successful are your investments. I was reading recently in a family office magazine about I think it was a brewery in Belgium that was in a type of trust structure, and the family who was sort of operating the brewery, it was the 18th generation. So, the trust structure was there to ensure that the asset remained intact and then could be, it's not a guarantee that the business is going to survive 18 generations, but it's a structure or a platform that can be used so that it doesn't go off in, different types of estate taxes or, get broken up by somebody who is more concerned about immediate gain versus the long-term, wealth creation for the family. Flexibility vis-a-vis the grantor. I would say maybe perhaps one of the number one things I hear from clients when they're contemplating setting up a trust is, well, I'm really concerned about control. I don't want to give up control. And I understand that completely. I mean, many of you are entrepreneurs. You've worked hard to make your money. You've made every decision about what to invest in. And my retort to that is, well, okay, so if you've got a beautiful condo here in Panama and you own it, you can get on the plane and you can come here anytime you want. You can stay as long as you want, and you write out the check for the property taxes. That's if you own it. If it's in your trust, you can get on the plane anytime you want. You can come down here. You can stay as long as you want, but your trustee writes the check for the property taxes. You okay with that? I mean, it's not a huge difference. The legal control is with the trustee, but remember, the reason for the legal trustee is to protect the asset for the beneficiaries. And in most offshore jurisdictions, a grantor can also be a beneficiary. So for many of my clients, they're concerned about protecting assets for themselves first and foremost, and then they want a smooth transition over to their children and grandchildren. So all I want to say is, no, if you go to your trustee and say, invest all my money, 50 to 1 in Vietnamese penny stocks, and the trustee can't say no, then you don't really have a trust. That's called a sham, right? But for the most part, the trustee has to exercise independent fiduciary obligation over the asset, but they're there to protect the asset for the beneficiary, which in many cases is you. So it's not like you're at odds with the trustee in any way, shape, or form. Okay. Also, outside the U.S., it's pretty commonplace to use what's called a protector, and the protector's role in some cases is to remove a trustee that is not doing things to the liking of the grantor, not of the beneficiaries. The beneficiaries don't have that power, right? So your children or grandchildren can't say, well, we don't like the amount of money the trustee's giving us. We want to replace the trustee. But you certainly can during your lifetime if you're saying, hey, every time I want to do something, the trustee's very uncooperative. But in my career, I've probably established well over 1,000 trusts, well over. And in 30 years, I can count on one hand the number of times I've ever been asked to help change a trustee. That's how infrequently that ever happens. All right. And then access to the global financial system. I mentioned that at the beginning, and that's one of the reasons why you want a trust to be outside the U.S.